41/11/2020, second April 4 to 6 of 2019.
May I please? The appellant is plaintiff. Suit filed by the plaintiff for declaration of his title was dismissed. Appeal filed, appeal also dismissed. Apart from declaration of title, the plaintiff also claimed relief that by virtue of one registered deed of sale dated 8/12/1970, the
8/12/1970.
70, the defendant number one, who had earlier purchased the food property by the same vendor, I have purchased subsequently, has not acquired title. This was also relief claimed by the plaintiff.
I don't get it.
Yes, plaintiff purchased the property in the year 1974 on 9 to
9/2/74.
Yes,
From?
from Sushil Jha.
He is a defendant?
No. This is admitted, the owner is Sushil Jha. This is an admitted case of both the parties. On 8/12, food property was purchased on 27/2/1974. 27/2/1974
Okay.
by the plaintiff. The defendant number one, original defendant number one, Urmila Devi, purchased the food property on 8/12/1970 from the same person. Owner was Sushil Jha. This is admitted case of both the parties.
From same person, the same
Yes.
property?
Yes.
Registered deed?
Yeah, registered.
So what right do you have?
Yes, yes. So this was the one of the most important aspect, which was it looks that we have no case.
That's right.
Yes, because subsequent sale deed has no.
That's right.
Now, but the case of the plaintiff is that the sale deed which was registered by the admitted owner in favor of the defendant number one, the entire consideration amount was not paid to the purchaser Urmila Devi.
By the purchaser?
By the purchaser, defendant number one. Defendant number one is Urmila Devi, in whose name 70 deed was registered, and defendant number two is her husband.
Who can have a grievance to this?
The second purchaser,
The Sushil Jha
yes,
has no grievance.
yes, he had grievance. He had grievance. So what he did? So first, my lord, the vendor, my lord, asked for money, did not got the money. So he executed and registered subsequent sale deed because his title was not affected.
No, you can't do this.
Yes.
He is not a party in the
My lord is correct. So
Is he a
it
witness?
appears that it cannot be. I do agree. Because once sale deed has been executed and registered, title passes sooner.
Certainly.
Certainly.
It can be deferred payment also.
Yes, deferred payment also. Now the question is that if this is this prima facie, I have no case. Now but when we filed suit, and admittedly the defendant number one and two appeared, filed written statement, and very interestingly admitted that yes, only a small amount was paid to the vendor, and there was a specific condition in the deed that we will pay the remaining amount, then we will take the purchaser will be able to take the original sale deed. Means the registered sale deed which was suppose executed and registered by me in favor of another person. So the original registered sale deed was kept in possession of the vendor. Because this was the title deed.
So,
Now, this original title deed was never taken by the first purchaser. So now both these sale deeds, means original sale deed was also produced, exhibited by the plaintiff. Earlier, original registered sale deed was produced by the plaintiff, not by the purchaser defendant number. Now, the learned trial court, now one other aspect, although in law that document has no validity in the eye of law, but since my lord has made query that what step vendor has taken. So when vendor did not get the entire consideration amount, because Chirkut was also with the vendor. So vendor, as per own understanding, went to the registry office and made unilateral, executed and registered unilateral cancellation, declaring that I have not been paid the entire consideration.
that is not permissible.
It is not permissible. So, my lord, that is I myself saying that this is not legally permissible, but only in order to show the conduct what vendor did.
Who was in possession?
We were in possession was the vendor.
Then who was in possession of the suit property?
We were because we filed an after purchasing the property, we went before the circle officer for mutation.
Mutation is anything.
No,
Did you claim
we
recovery
are in
of possession?
position. No, we are in position.
No relief for recovery of possession.
Direct not relief. We found this possession during the pendency.
So, क्या मतलब?
Because why? Because no relief for recovery of possession. Why? Because it has not been solved. Because in the sale deed of the defendant, there was mention that the property has been surrounded by making boundary wall. Plaintiff said that I am in possession. Defendant said no, we are in possession and we have surrounded the suit property by constructing boundary wall. So the possession I am arguing against me. Now, if the defendant number was in possession, statement of the defendant number one first purchaser was complete in contradiction with their own document by virtue of it.
You are the plaintiff, no?
Yes, I am.
Get out your own case.
Yes. So we were in
Get out
possession.
your own case.
Yes, because in there was a proceeding of 145, and in that proceeding my possession was declared. Subsequently, I have exhibited that document also. Subsequently, that 145 in a proceeding under section 145, my possession was declared.
As per the findings, who is in possession?
No, both the trial court has not given any specific, rather said the title passes soon after the execution and registration of the first deed. So, consideration amount was paid, taking into consideration.
The merely because a cheat code was there with the owner of the property.
Not really, there were two documents. One cheat code and second the original sale deed. If
Cheat code and original sale deed is one and the same thing almost, because cheat code will be given and then you get the
correct,
original sale deed.
correct,
Right.
yes. So my lord, so that this was
Only the original sale deed must have been exhibited by him, not the
yes,
chipbook.
not chipbook because it was given. So there was two things. Next thing was that the defendant come with a case. I am showing, I am arguing my weaker points first. My lord took the notice of the my lord's consideration. Now the defendant's property was purchased by the defendant number one in the year 1970. They have one shown produced one money receipt of 1971. Money receipt of 71 that I have given the money to the vendor and he issued money receipt. So this was their best case. Now we have to prove that by virtue of 1970 registered deed, title passed to the purchaser or not. We have to prove. Now the best evidence, minority is well aware that if a document is reduced into writing, then that is the best document. So the document was produced and both the court has taken note of it and also admission by the defendant that there is a specific recital in the registered deed itself that entire consideration amount was not paid. And second, no date, any future date is fixed for payment of rest consideration. It cannot be indefinite period. If I am purchasing, if I have no amount, remaining amount, then certainly there will be certain that I will pay on such and such date or certain such and such. So there was no date fixed in the deed. I have also a copy of that. Now the learned, both the courts, my lord will find. One taken consideration of the established mandate of law regarding section 54 of the Transfer of Property Act. Taken note of it that in such circumstances, when from it, the admission or the document it can be proved that consideration amount was not paid, then what will be the consequences? So the first decision was Janak Dulari, this is reported in 2011 Supreme Court 2521.
2000?
AIA 2011 Supreme Court 2521. And so the Honorable Apex Court, this was also a case at the time of Unified Bihar, and by the Supreme Court it has been, specifically it has came in the judgment which is against me, that this is the specific practice in Bihar, Unified Bihar, that if consideration amount is not paid, then chiput is being kept by the vendor, and if consideration amount is not paid, then the title will not pass. And taking the learned first appellate court taken note of this. In spite of that legal mandate, the learned appellate court has held, no, once sale deed has been executed and registered, title passes. So my case is only based upon interpretation of section 54 read with the document exhibit 1 which was the registered sale deed of the defendant number 1.
It was a registered sale deed.
Yes, my deed.
No, wait, what is the original sale deed? Exhibit number?
1.
That is the original sale deed,
Original sale deed.
not the certified.
No. My lord, can you take note of it, my lord? It is in paragraph, this my lord showing. Paragraph 6, my
And
lord.
if the amount is paid,
Exhibit 1 by 8.
this,
that is exhibit 1 by 8.
just a moment,
Yes.
the payment,
Yes.
the money receipt of 1971,
Yes.
has it been proved and believed or not?
No, it has not been proved
No, why not proved?
because he produced a money receipt
What is the finding on that?
that the money receipt has been given. So that finding is against me. That has been realized. that has been
That has been realized.
Yes.
Therefore, under such circumstances,
Yes.
where the differential amount is paid,
Yes.
but still the original owner does not hand over the.
Yes, yes.
What will happen?
Exactly. So that's why, my lord. So if the case was that in the 71, if money was paid, then purchaser was to take any action.
He
And
might not have taken, but the ones.
my lord, if I am purchasing any property, immovable property, and if I have no title document, then certainly I will be living upon vendor. I will wait for 6 months, 1 year, 2 years, 3 years, 4 years, 5 years, 6 years, up to indefinite period. I will not take any step. I will not take any step, and specifically this has been cross-examined on this point also. The purchaser was a lady. She didn't work. She died during the pendency of this. Husband came. A specific question was asked. Specifically answered in paragraph 45. No, we have not taken any step. So now the question was, once the the learned first appellate court taken note of the decision law regarding interpretation of section 54, that if this was the specific practice developed in Bihar, that if original if consideration amount is not paid, Tirkut is being kept, original schedule is in custody of the vendor, title will not pass. The learned first appellate court has committed grave illegality, my lord, by dismissing my appeal. Kindly take section 9, paragraph 19, my lord, for a moment.
Where is this Devantula judgment?
That's yes. That has been quoted also in the judgment. And apart from that, one recent judgment is also, which says 2025 judgment I have brought, that if any registered sale deed consideration amount is not paid, recital is there that entire consideration amount is not paid, then there must be in the deed itself certain specific future date. And if it is not there, the sale deed is void. I will show that better it will be. Just before para 19, my lord, will find it has been underlined in the Supreme Court decision cited, my lord, specifically holding that there must be some future date.
Read it.
My lord. Hence, after taking into consideration section 54, just relevant, my lord. Hence, a sale of an immovable property has to be for a price. The price may be payable in future. It may be partly paid, and the remaining part can be made payable in future. The payment of price is an essential part of a sale covered by section 54 of the Transfer of Property Act. If a sale deed in respect of an immovable property is executed without payment of price, and if it does not provide for payment of price at a future date, it is not a sale at all in the eye of law.
It does not say future specific date.
Yes. So there was no date.
No, it does not say that there has to be a specific date.
At a future date,
Future date
any.
means deferred payment. As simple as that. Contract Act talks about deferred payment.
Yes, my lord. But had it been the intention, had it been the dictum of this decision, my lord, I go down with my lord's observation. My lord, date could not be written in this judgment. Specific, this term has been used, date. So my lord, my submission is 70 का registered sale deed कोई भी तो step लेते इसी साल 4 years 5 years
कोई भी चीज का स्टेप नहीं है उसका रिकवरी ऑफ सेल लेकिन टाइटल पास्ड ऑन द मोमेंट द सेल
no if it is not no it is of no legal effect. So once we have proved that no step has been taken, specific there was terms that paid consideration amount was not paid.
You see, you can have a situation where you say that consideration amount is 2,000
Yes.
1,000 is paid, and the sale deed is silent regarding any further payment,
Yes.
then that is void.
Yes.
Correct?
Yes.
But if the sale deed says that the remaining amount will be paid
Yes.
in future,
Yes.
no specific date mentioned,
Yes.
then also it will be void.
Yes, my lord. It's been literally void. Why? Because, my lord, my lord, just consider. I'm raising myself, my lord. If I am the purchaser, can I left
See,
this?
what a litigant would do is different.
No,
But the point
a
is
common
that what the law says.
law says.
Contract ad-
Kindly see 2011 judgment, my lord. Kindly see 2011 judgment. It is also quoted in paragraph 19 of the Act.
transfer property.
Now kindly see, my lord, kindly take, my lord, 2011, because this has been time to time. Earlier there are full bench decision of the honorable our parent High Court, Patna High Court, my lord. Kindly take decision of honorable Apex Court, my lord, quoted in 2011. Paragraph 24. My lord will allow.
And 24 of this time?
2011 judgment. I have given just now. It is on the last page. Yes, last page. 569. Paragraph 24. I may be allowed. We hasten to add that the practice of tak hujur badlan of title passing on exchange of equivalent is prevalent only in Bihar. Normally the recitals in a sale deed about transfer of title, receipt of consideration, and delivery of possession will be evidence of such acts and events. And on the execution and registration of the sale deed, the sale would be complete even if the sale price was not paid, and it will not be possible to cancel the sale deed unilaterally. The exception to this rule is stated in such and such. The practice of tak abjud badlan in Bihar recognizes that a duly executed sale deed will not operate as a transfer in presenti, but postpone the actual transfer of title from the time of execution and registration of the deed to the time of exchange of equivalent, that is registration receipt and the sale consideration. If the intention of the parties was that title would pass only on payment of entire sale consideration, as a result, until and unless the duly executed and registered sale deed comes into the possession of the purchaser, or until the right to receive the original sale deed is secured by the purchaser by obtaining the registration receipt, the deed of sale remains merely an agreement to be performed and will not be a completed sale. But in states where such practice is not prevalent, possession of registration received by the vendor may not, in absence of other clear evidence, lead to an inference that consideration has not been paid or that title has not passed to the purchaser as recited in the duly executed deed of conveyance, where the purchaser is
See,
from.
there are two conditions.
Yes.
As a result, until
Yes.
and unless the
Yes.
due execution of registered sale deed comes into the possession of the purchaser, this is
First,
one.
yes, my lord.
Or until the right to receive the
Yes.
original sale deed
Yes, my lord.
is secured.
Yes.
It is the right to receive,
Yes.
not that he actually
Correct.
receives it.
Correct. Correct. Yes.
So the moment in 1971 he paid the entire consideration amount, the right to receive was secured with him.
No.
Why not?
No. If right to receive was secured, that's why at the very first moment, my lord, this was my first argument, that if right to receive was obtained, then there was no question that the original sale deed, registered sale deed.
The right to receive was obtained, but he did not take any action to receive.
My lord, if
These are two different things.
if
The
second.
right to receive is one thing,
Yes.
and actually taking any action
Yes, right
or
means
legal
another-
action
My lord,
to
I
receive
vote.
that.
I vote on. I understood, my lord. The right meaning thereby that entitlement to receive.
Yes.
Yes. Now my lord will find that if entitlement of was received accrued on that day, my lord, the original registered sale deed was to be in possession, because this is not a case that I went there, I given money, but he has not given money receipt.
No, money receipt was given.
Money receipt was given.
Yes.
Therefore, my lord, therefore there could have no other option but to deliver the original sale deed to the purchaser.
Right to receive accrued on the day he paid the balance consideration.
Yes.
Then
Now,
what steps he has taken is another thing.
yes, my lord is correct. So when registration receipt was when the vendor was offered to sale, now my lord, original sale deed was not in custody of the purchaser.
That he has explained.
Where, my lord? Where? No. This is in support of it. That is in my support. His explanation of defendant number one purchaser did not come. Her husband came and he had his explanation is in my support. Kindly see the written statement. Kindly see the written statement and kindly see the exhibit 1 by A. That is in my support.
Now you read the reference. Finding पढ़ाइए.
Yes.
पहले issues फिर finding.
My.
Case of defendant देखते हैं. Plaintiff का तो केस पता चल गया.
मैं आपको डिफेंडेंट का केस पहले बताया, देखा थे पैराग्राफ 4 देखा थे. But I always point out my weakness first. Paragraph 4 देखा थे. This is the case of the defendants. The defendants by filing a WS, my lord, it is on internal page number 5 of the first appellate court session. The defendants by filing a WS have challenged the maintainability of the suit on several grounds that the plaintiffs have got no cause of action for the suit and the plaint is not properly verified and suit is barred by law of limitation, waiver, estoppel and adverse possession. It is averred that the name of Sushil Jha, who purchased the land from Seval Ram on 26/7/63 and said Sushil Jha in need of money required to sell the suit property to one Bhola Nath at rupees such and such, and it was agreed that out of, kindly take note of, property to one Bhola Nath, and it was agreed that out of consideration amount of rupees such and such amount of rupees 500 would be paid at the time of registration and balance rupees 1500 would be paid later on. Sushil Jha accordingly sold the land in dispute along with compound wall for a consideration of rupees 2000 by registered deed of sale dated 8/12/1970 bearing deed number such and such, and put the
It was a clause in the registration deed
Which one?
that remaining will be paid?
Yes, yes, my lord. Otherwise, I could not have. I could not have any argument, my lord.
You have got a copy of it?
Yes, yes.
आगे बढ़िए.
It was also agreed that the chipmunk of registration office will be handed over to the vendee when the balance sum of rupees 1500 would be paid to Sushil Jha. So this is important pleading of the defendant. It is also averred that in the month of March 1971, the defendants approached the contact Sushil Jha in order to pay the balance sum of rupees 1500 and to get the chipmunk. But Sushil Jha was not found at the office when the defendant number 2 met Sushil Jha on 26/5/1971 and offered him to take the balance sum of rupees 1500 and to hand over the ticket. Sushil Jha said that ticket had been lost and he hoped to obtain the duplicate ticket from the registry office Dharibagh. For it, he would to give expense of rupees 100 extra. Thereafter, defendant number 2 gave rupees 1600 to Sushil Jha on 26/5/71 and date is very important one. And Sushil Jha gave a receipt in token of the sum of rupees 1600. Further averred that the defendants made several demands to Sushil Jha for the return of salary, but Sushil Jha gave several pretexts and assured the defendants that he will hand over the said tribute. And thereafter, the defendant constructed a hut over the suit land and applied for mutation to Anchal office, which was allowed in his name. Further, defendants averred that municipal authority, after being satisfied with his title and position of defendant number 1, sanctioned his plan by office memo number 21/75 and the defendants started to make preparation of the construction of the building. It is averred that defendant number 1 on 1917 to 1975 received a letter from Jumrikilia municipality that once Srimati Bai Devi is trying to get building plan sanctioned and construction over the disputed plot number such and such. It is also came with their knowledge that one Banwari Lal Kedia got the salary executed from Sushil Jha after cancellation of his earlier salary, which was cancelled on 9/2/1974. The entire consideration money of disputed land was paid by the defendant to Sushil Jha and the defendants are in peaceful possession with right, title, interest thereof. Further averred that from the date of execution, the said vendor Sushil Jha never came in possession over the suit land, nor he had any right, title, interest or possession over the disputed land. It is averred that Banwari Lal Kedia had got a vague sale deed executed in his favor on 17/2/1974 in the name of his wife Bai Devi by Sushil Jha, and on the basis of alleged sale deed, Bai Devi and her husband started to claim the disputed land. It is further averred that CEO Kodarma has rightly rejected the petition filed for mutation filed by Bai Devi and LRDC Kodarma wrongly allowed the mutation appeal of the disputed land owner. However, the additional collector rightly set aside the order of mutation appeal by his order dated 15/10/81. The learned commissioner by order dated has been pleased to remand the case on the ground that Srimati Bai Devi alleged to have been declared to be in possession under section 145 CRPC and the proceeding was drawn at the instance of Srimati Bai Devi and her husband, and the same was decided on such and such date in her favor. Against the order, the defendant preferred criminal division number such and such before additional session judge Hazaribagh, and the alternate additional session judge, after setting aside the order dated 11/12/1980, remanded the case for re-hearing and deciding the case in accordance with law, and after remand, the proceeding under section 145 CRPC in respect of the suit land was decided by the executive magistrate in favor of the defendants, and their possession was declared by order dated 9/11/1996. Further averred that Sushil Jha had already received consideration money of disputed land, therefore he executed money receipt for rupees 1600. It was contended on behalf of the defendant that the order dated 9/11/1996 has not cast cloud upon the title and position of the plaintiff, and hence there is no necessity to filed the present suit and the plaintiff is not entitled to get any relief or reliefs as claimed. Thereafter, 9 issues have been found, framed, my lord. The learned first appellate court, my lord, thereafter recasted the issues, which is at paragraph 12. Internal page 14.
These are the points for determination.
Yes, point for determination. Whether the point for determination was filled, whether this edit, this has been mentioned, ma'am. Thereafter, kindly see, ma'am, paragraph 13. Second paragraph.
Yes.
It is an admitted fact that the vendor of both sides, Sushil Jha, executed a sale deed in the name of defendant number 1 of the suit with respect to the suit land on 8/12/1970. The same original of the same was filed on behalf of the appellant plaintiffs, Exhibit 1 by B. It is the case of the plaintiffs that the purchaser defendant did not pay the consideration money to vendor Sushil Jha at the time of execution of registration of sale deed. Before that, he had assured that he would pay the consideration money after taking Chirkut. But despite several requests and demands made by the vendor, the defendant purchaser did not pay the consideration money, and therefore Chirkut was not exchanged, and the vendor continued in possession of the suit land, having right, title, and interest thereon. The sale deed in favor of the defendant number 1 is illegal, void, without consideration, and tainted with fraud and deception, and did not and could not confer any title in favor of the purchaser defendant. It is averred in the plaint itself that defendant falsely claiming that they have paid consideration money to the vendor, and vendor executed a receipt of receiving rupees 1600 as consideration money and cost from the defendant, and the fact regarding execution of money receipt has been denied in the plaint. On the other hand, there is specific pleading on behalf of the defendant that it was agreed that out of total consideration money of rupees 200 for the sale of the suit land, rupees 500 would be paid at the time of registration, and balance sum of rupees 1500 would be paid later on. Rupees 500 was paid to the vendor at the time of registration of the sale deed, and it was agreed that chirkut of the registry office was to be handed over to the vendor when sum of rupees 1500 would be paid to the vendor. The defendant tried to contact the vendor for payment of balance amount of rupees 1500 and getting the registration slip, but the vendor was not found, and ultimately on 26/5/1971, rupees 1600 was paid by the defendant number 2, the husband of the defendant purchaser, to the vendor as rest consideration amount, as well as rupees 100 as expenses to be incurred for obtaining duplicate copy from the registry office due to loss of original, and it was assured by the vendor that after getting the original sale deed from the registry office, he would hand over the same to the defendant number 2, but despite several demands, the vendor did not hand over the original sale deed to the defendant on one pretext or the other. The learned counsel of the plaintiff has argued that it is a settled principle. So, thereafter, my argument is that, may I continue or will you continue with the findings?
You continue whatever you want.
My lord, kindly see, my lord, paragraph, my lord.
You are referring to para number.
I was
Just enumerate the paragraph.
15.
Paragraph 15. And which other paragraph you want to use?
No, my lord, just I 15, my lord, 15 just.
Any other paragraph of it? I just want to know.
Thereafter, I will show the from the finding code. Paragraph 15. Thereafter, my lord, 15, 16, and 19. These paragraphs are, my lord, the law of the Honorable Apex Court, very detailed conditions regarding section 54 has been dealt with. Now, my lord, kindly take note. Just
145 proceeding was not in your favor.
it was in my favor. There it has been challenged.
Ultimately, 145
No,
proceedings.
yes. Now I have a point. Well, kindly see. 145 proceeding was there. It was challenged by them. It was reminded. They come with the pleading that thereafter 145 proceeding has been decided in their favor. Yes, but that document they have not brought. So that document they have not
You
brought.
are also claiming 145 proceedings in your
Yes,
favor.
and I brought on the record.
With final order.
Order, first order, not final, my lord. First order passed by the 145 court, and thereafter second order, court, my lord, by virtue of which the matter was remanded only on the ground. Both are on the record.
What? That's right. Where is the final order?
Final order I have not brought.
Why have you not brought? Because that is incomplete.
Yes.
Because 145 story becomes incomplete.
No, because my
If
lord.
a matter is remanded, then it is not taken to a logical end at all.
Now kindly see, my lord, this one.
And rather, what is your cause of action?
My cause of action, this one, my lord, when my mutation was LRDC allowed my mutation, and in revision, my lord, my mutation was set aside. My mutation was set aside. Exhibit 2 by 1, my lord, kindly have a look to page number 9.
The cause of action, you see, the
There are two cause of
just a
action.
moment, the
Yes.
learned executive magistrate erroneously and illegally declared on 9/1/96 the possession of the defendant over the suit land.
Yes.
This is your case?
Yes.
So, it is an admitted fact that the possession was ultimately declared in favor of the defendant, and that is your cause of action.
Order of the executive magistrate.
Yes. So, it is an admitted fact. They need not produce the final order. It is an admitted fact that by the order dated 9/1/96,
Yes.
the possession of the defendant was declared.
Yes. That
So, how does it make a difference whether they produce the final order or they don't produce the final order?
There was a reason. There is always a reason. A judgment, my lord, I will not argue on that point. I will not argue. My lord, if I must be able to, my lord.
I am still not able to figure out a point of view. Para 18 पर 15, 16, 19 तो काउंट कराए, 18 छोड़िए.
18 ठीक हमको
18 पढ़िए ना, 18 is clinching.
Yes. It is quite clear that the rest consideration amount was not paid by the purchaser at the time of execution of the sale deed in question. However, there is no recital in the sale deed of the respondent defendants to the effect that transfer of registration slip would be condition precedence and evidence of transfer of right title interest of the suit land in favor of the purchaser. Rather, there is a specific recital regarding cessation of right title interest of the vendor over the suit land from the date of the execution of the sale deed.
Was here. There is a specific recital.
Yes.
That the title is passing on that particular
Yes.
date. So
Now, my lord, my lord, I may be permitted to, my lord, to submit the exact law which has been enunciated by the Honorable Apex Court.
yes.
Yes. Now.
Does it say that irrespective of
Yes.
any
Yes.
recital in the same deed,
Yes.
that the
Exact.
irrespective of any recital in the same deed,
Yes,
that the
yes,
title
yes,
immediately passes,
Yes.
still the
Nahi.
title would not
My lord,
pass.
exact word we cannot find. But my lord, can you
No
again?
exact word. This is a very important word.
Yes, exact
You have
word
to
not
show
but
something of this tenure. Read Andy Bulari's case and the facts of this case. Please read it.
no. Yes.
Please read it. Because this is the most important judgment you are referring to, right?
This one in 2025.
We'll come to 2020.
Yes.
This is directly coming from Jharkhand.
Yes.
Read it. What is the facts of this case?
My lord is saying I will signal. I will say, my lord, dismiss my second. But my lord, after going through
You see, when there is a specific recital in the sale that the title passes, then the deferred payment,
yes,
the amount
yes,
is certainly, it is open to the plaintiff, the vendor, to seek recovery of the balance consideration. Had they, if the decedent is silent on that point, right? It only says that there will be
It
a
was
default
not
payment.
silent. It was not silent.
It was not silent.
No, no.
I want to see it from Janakula. This Janakula.
Janakula, yes.
Please read it. Read it, please. Para number 2.
Well, I will read it. I will read, my lord. Again, kindly allow me, my lord. I will
I am
read.
allowing you for 1 hour.
My lord, you always grant, my lord. I am grateful, my lord. Kindly see again, my lord, paragraph 24 of that judgment.
I will not read just paragraph.
My lord.
I'll certainly
My
read
lord,
the
this
facts
the
of
plaintiff
this.
in a suit for a specific performance agreed by the judgment and decree of the Patna High Court dated 3/1/2022, dismissing his second appeal against the decision of the first appellate court dated 16/12/1997, dismissing their suit, have filed this appeal by special leave.
This was from specific performance.
Yes.
Read paragraph 2.
The case of the appellant in brief is as under: the second respondent was owner of the suit property. The second respondent executed a sale deed dated 22/2/1988 in respect of the suit property in favor of the appellant for a consideration of rupees 22,000. That rupees 70,000 was paid by the appellants to the second respondents at the time of execution and registration of the sale deed. That the balance of rupees 5,000 was to be paid subsequently when the vendor requested for the said payment, that the second respondent retained the registration receipt in regard to the sale deed, agreeing to deliver it to the appellants against payment of the balance and consideration, that on execution of the sale deed by the second respondent, his right, title and interest in the suit property passed to the appellants, and possession of the land was sold was also delivered to them, that subsequently the second respondent avoided receiving the balance of rupees 5,000 and failed to deliver the registration receipt. That the appellant issued a legal notice calling upon the second respondent to deliver the registration receipt so that they could collect the original registered sale deed. But the second respondent sent a reply denying the receipt of 17,000 and stating that the entire consideration was due, and that therefore it became necessary for the appellants to file the suit. The appellant sought a decree for a direction to the second respondent to deliver the registration receipt relating to the sale deed dated 22/2/1988 by receiving the balance consideration of rupees 5,000, and that in case the second respondent had already obtained the original sale deed from the office of the sub-registrar, then for a direction to deliver the same to the appellant. The suit was valued at rupees 5,000. The second respondent filed his written statement. He alleged that he had agreed to sell the property as he urgently required the money for celebrating the marriage of his daughter, that he executed and registered the sale deed on 22/2/1988, that the appellant did not pay any part of the consideration, and allegation that he had paid rupees 17,000 towards the sale price at the time of execution of the sale deed was false, that the appellants had played a fraud upon him by stating in the deed that rupees 17,000 was already paid towards the sale price, and making him sign the sale deed without reading the deed. That when he demanded the sale price, as the appellant stated that the sale consideration would be paid later, he retained the registration receipt and did not deliver possession, that it was the intention of the parties that title in the property should pass to the appellants and possession should be delivered only on payment of the consideration of rupees 22,000 by the appellant. That as the appellant failed to pay the sale consideration, he cancelled the sale deed dated 22/2/1988 on 18/3/1988 and sold the property to the first respondent on 29/8/1988 for a consideration of rupees 19,000, and also delivered possession of the property to the first respondent, and ever since the first respondent is in possession of the suit property. He contended that as the title and possession remained with him even after execution and registration of the sale deed in favor of the appellant, and as the sale price was not paid, he was justified in cancelling/rescinding the sale, and appellants were not entitled to any relief. The subsequent purchaser was thereafter implicated as the second defendant in the suit. The court framed appropriate issues as to whether the sale deed executed on 22/1988 was for consideration, whether
बताइए अपना क्वेश्चन ऑफ लॉ.
But only misconstruction of section 54 and exhibit 1 by B. Question number F. केवल इसमें सेक्शन 54 है.
अगर इतना ही बना दे, whether the findings under in paragraph 18 of the appellate court judgment is contrary to the judgment, that will be sufficient. The sole question. Second appeal number 426 of 2019. The learned counsel for the appellant has argued at length and has submitted that the plaintiff has lost in both the courts, but still a substantial question of law arises in this case. He has submitted that the defendant number 1 was claiming title over the property by virtue of registered sale deed dated 8/12/1970. And admittedly, at the time of registration of the sale deed, only part payment was made, and the chirkut as well as the vendor of the defendant number 1 did not hand over the chirkut to the defendant number 1 as part consideration amount was still payable, and ultimately the defendant number 1 could never get the original sale deed. He submits that the original sale deed was produced by the plaintiff before the court. The plaintiff purchased the property from the same vendor by registered sale deed dated 27/2/1974. The learned counsel has further submitted that the defendant claimed that the remaining consideration amount was paid, and a money receipt of 1971 was also issued by the vendor of defendant number 1, but the original chirkut or the original sale deed was never handed over to the defendant number 1. The learned counsel has submitted that the defendant number 1 did not take any steps for recovery of the original sale deed. He also submits that the title did not pass to the defendant number 1 on account of non-payment of the consideration amount, full consideration amount. He submits that only 500 rupees out of 2,000 was paid at the time of registration of the sale deed. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 2011 bracket 06 SCC 555 and has submitted that the title does not pass unless the original sale deed or the chiefhood is delivered to the buyer. This was peculiar in connection with the state of Bihar and Jharkhand being a part of state of Bihar. Same practice prevails, which has been judicially recognized by the Honorable Supreme Court. He submits that the findings recorded in paragraph 18 of the learned First Appellate Court's judgment is contrary to the judgment passed in the case of Janak Kulari Devi versus Kapil Dev Rai, reported in bracket 2011 bracket 26 SCC 555. ये same principle है?
Yes, yes.
He submits that he has also referred to a recent judgment of the Honorable Supreme Court reported in 2025 SCC online SC 1961 Shanti Devi versus Jagan Devi. Any paragraph?
Yes, madam. It is in paragraph 34 where it has been given by the specific, if payment is to be made in future, there must be a future date is given in the decision as a future date.
Future date is not a specific.
No, no.
इसको छोड़ देना.
Madam.
In view of the ये दूसरा वाला judgment छोड़ देंगे, ठीक है? In view of the aforesaid submission, this second appeal is admitted for final hearing on the following substantial question of law: whether the finding of the learned First Appellate Court in paragraph 18 is contrary to the judgment passed by the Honorable Supreme Court, reported in bracket 2011 bracket 26 SCC 555. That should be sufficient.
Madam.
Issue notice to the respondents for which requisites under speed post be filed within a period of 1 week.
Madam.
Let the records be called for from the concerned court. Office to track speed post delivery. Owes this case for final disposal on 7th of October.
Deep.
Records be called for at the special for deposit of special messenger cost by the appellant within 1 week.
Madam.
रहेगा तो सुनेंगे.
मैंने हमेशा टाइम देते हैं और सबसे ये बियॉन्ड रिकॉर्ड बोल रहे हैं कि पूरा बोलने का जब रहता है तो लगता है कि सब कुछ बता दे, डिसमिस होता है तो भी खुश रहते हैं कि अपना बेस्ट एफर्ट लगाए, बस यही.
देखते हैं क्या करता है.
डीपली ग्रेट.
वो जो क्लॉज है उसका क्या इम्पैक्ट है वो देखना जरूरी है.
Madam.
Whether it has to be mechanically seen या उसका क्या legal impact है, क्या contractual impact है. Because there is a clause that the title is passing,
Yes.
that we have to see what is the impact.
Deep.
7 नहीं 7 अक्टूबर नहीं हो सकता. नहीं विद अक्टूबर चलिए.
अक्टूबर सर.
सॉरी सितंबर कर देते हैं. 11th of November. Sorry.
Deep.
Final disposal.
Item 21, second appeal 433 of 2019.
This judgment is reversal.
What is the question?
So in this case,
What was the suit for?
the partition suit was filed by the son against the family members for 1/7 of the sale. Now the learned trial court has decreed in favor of the petitioner, the appellant, and the appellate court has reversed. The only moot question which has come in this case is whether the property which is a scheduled property, schedule A property, whether this has been purchased by the father of the petitioner or it is a self-acquired property of the mother of the petitioner, mother of the applicant. This is the only. In the trial court,
Mother is the plaintiff.
mother is a
Sorry,
different appellant is for the plaintiff.
This is the appellant's, the plaintiff's appeal.
Yes,
The trial court decreed
decree
to the extent of 1/7.
1/7.
The by saying that it is the property of.
Property of the father of the appellant, and he is the legal heir, and so 1/7 shares will be given.
Okay.
Now the appellate court has reversed it on the ground that this property was purchased by the dependent number 1, who is the mother of this appellant, through his own source of income. This is the only which has come. Personally, can see the appellate is the
So consequently, the appellate court has done what? Has not given any share because the mother was
Yes.
mother is alive.
Yes.
Mother was
is
contesting.
yes.
Mother was contesting.
She is dependent number
माँ बेटा सब लड़ रहे हैं.
property.
पहले ट्रायल कोर्ट का फाइंडिंग.
जी, page 49.
प्रॉपर्टी किसके नाम से?
Father. Sorry, dependent number mother claims.
तो ये फादर का प्रॉपर्टी कैसे?
Because in the year 1993, the father has given a statement before his office. He was working in the same MRI. He has given a statement of assets and liabilities, and he has given every details that this was purchased from his own income. That is,
तो उनके डिक्लेरेशन से नहीं होगा.
जो
उनके
property was-
डिक्लेरेशन से नहीं होगा. उसी डिक्लेरेशन ऑफ द प्रॉपर्टीज जो भी है घर में दिया जाता है, उनके डिक्लेरेशन से कैसे होगा? और कौन प्रूव करेगा उनका डिक्लेरेशन?
finding has come.
उनका यूनिलैटरल डिक्लेरेशन से खुद ही डिसाइड हो जाएगा.
सिर्फ वही नहीं, और भी है.
What is मतलब he must have taken loan for the property. How did he purchase the property?
He was in the government service.
So what
Yes.
is the source of income?
Also, the property
He must have withdrawn money from the bank account to purchase this property.
that has not come.
That
What
would
has
not
come?
come.
What has come in the entire evidence? The defendant number 1 has been examined. It has come that she was having no source of income.
Maybe.
Rather, she is saying that she has purchased this land through her own stridhan and help from father. Now, she has already given her statement before the land trial court itself. His father has been no economic condition that was very bad, and she has got whatever she has purchased from the street. What she has no source of income. Whatever she has been saying, she has no source of income. Now, this property was purchased. One property was purchased in the name of dependent one and the plaintiff, this appellant, and the one of the properties were purchased in the name of earlier mother, who has died issueless, and the rest of the properties were purchased in the non-dependent number one during the lifetime of the father. This was the case. Now,
The appreciation of that कैसे होगा?
इनका खुद का
It's
एविडेंस
a substantial question of law क्या है? Perversity दिखाई. नहीं, you see, second appeal में reappreciation of evidence नहीं होता. कोई law any question of law is not substantial question of law. Every question of law is not substantial question of law. This is not what I am saying. This is what the Supreme Court has said. Right? Unless you show me कि भाई ये evidence को नहीं consider किया है, इसीलिए the judgment is proposed. Show me which evidence has not been considered.
so we can go to page 49, the London trial court. 3 issues were framed.
Yes.
The main three issue number 3, 4, and 6. That is maintained. It's paragraph 8. Since these issues are the most important issues, therefore the same are taken for first for consideration. On presume the pleading of the parties as well as after hearing the counsel of the parties, it transpired that it is the admitted case of the parties that the plaintiff father, late Madan Prasad Chaurasia, was the original resident of village Mou, PS Mou, district Gaya. He had ancestral and residential house and property there. He joined service in CMI Dhanbad long ago, where he was working till his death. Madan Prasad Chaurasia married Srimati Kasida Devi, who died issueless. Thereafter, he married to Srimati Pratima Devi, dependent number 1, from this letter the plaintiff and dependent number 2 to 6 were born. Madan Prasad Chaurasia died on 28th of 12th 1994 due to cancer. After his death, his son Arun Kumar Chaurasia, that is the plaintiff, got compassionate appointment in CMI Dhanbad. The case of plaintiff is that the late Madan Prasad Chaurasia from his earning had acquired the property described in Schedule A of the plant in the name of his wife, dependent number 1, and the plaintiff. Since the year 2001, some bickering started in the family as the dependent number 1 has sold one of the property described in Schedule B without any knowledge or information to the plaintiff and declined to share the proceeds thereof with the plaintiff. Per contra, the case of the defendant, as can be cut out from their pleading, is that the suit land mentioned in item number 1, 2, 3 of the Schedule A are self-acquired properties of the defendant number 1 and not of her late husband. She has purchased the said land out of her own money, including Sridhan, and with the financial help of her father, dependent on the person claiming self-acquisition with their own funds without using the available joint family nucleus in the case on hand. Since the defendant had not disputed in unequivocal terms the contention of plaintiff that the landed property mentioned in item number 4 of Schedule A was acquired by the late Madan Prasad Chaurasia from his own earning, therefore the same stand admitted. Although the law is well settled that the admitted fact need to be proved, still the statement of inward property on the first appointment furnished by the late Madan Prasad Chaurasia on 8/10/1993 to his employer, that is the CMRI Exhibit 1, so that in column number 9 it is mentioned that all the properties mentioned therein were purchased by him from salary, savings and PF. It is to be noted here that Exhibit 1 is dated 8/10/1993, that is much prior to the filing of this suit. Moreover, defendants have not controverted this claim. Further, the defendants have candidly admitted that the Schedule B property is the ancestral property of the parties. It is also not in dispute that the late Madan Prasad Chaurasia was employed in CMRI Indore, and he died while in service, and therefore he had sufficient source of income to purchase or acquire the Schedule A properties. And as such, neither the plaintiff nor the defendant number 2 to 6 have got any right, title, interest, and possession over these land. Hence, there is no unity of title and possession in respect of the said land. As far as the suit land of Lohara, P.S. Rafiganj, District Aurangabad, appertaining to Khata number 40, Schedule B are concerned, the defendant number 1 has no objection if these lands are partitioned by meets and bound in equal 7 shares among the plaintiff and defendant. The defendant number 6, by filing separate written statement.
The ultimate finding is this is the case, this is your case. What is the finding? You are reading your case. Where is the finding?
I'm just. Page 32, paragraph 20.
Page 22.
Page 32.
32. I am at page 53.
Appellate court orders.
I am reading the trial court statement.
Trial court. Yes, just. Sorry. Page 55. The last paragraph. Thus, on the basis of the discussions made herein above, I find that there is unity of title and position among the plaintiff and defendants, and the Schedule A land is not the self-acquired property of the defendant one. The plaintiff is entitled to partition in respect of the land described in Schedule A and B. Accordingly, these issues are decided in favor of the plaintiff and against the defendant. Page 57, the order is given.
What is the appellate court statement?
Yes. The appellate court order starts from page 24. The relevant is at page 32.
Page
32. Paragraph number 20.
yes.
After considering the submissions of the learned counsel for the parties and peruse the entire record, I find that the parties have confined their argument only with respect to the properties mentioned in item number 1, 2, and 3 of the Schedule A. Admittedly, the property stands listed in the name of Pratima Devi, defendant number 1. Pratima plaintiff has relied on Exhibit 1, which is the statement of movable and immovable properties on first appointment as on 1/1/1983, given by the late Madan Prasad Chaurasia. in the said statement, it is mentioned that the land was purchased in the name of his wife and source of income was shown from salary, savings and PF. Whereas dependent number 1 has claimed that the property registered in her name is her self-acquired property purchased from Stridhan or gift from her father. After considering the submissions advanced on behalf of the parties as well as considering the various judgments of the Honorable Court, it is clear that onus was on the plaintiff to show that the aforesaid land registered in the name of dependent number 1 was purchased from the joint nucleus of the family. Except Exhibit 1, plaintiff has not brought any document on record to show that the properties registered in the name of the Pratima Devi was purchased from the joint nucleus of the family. Thus, the plaintiff has failed to discharge the initial burden that the properties were purchased from the joint nucleus of the family. So far, the unity of title and unity of position over the suit claim is concerned. Plaintiff has not brought on record any title document with respect to the item number 4 of Schedule A. There are altogether 2 acres 5.75 decimals land in item number 4 of Schedule 4A. There is no document on record regarding the title of the parties.
What do you mean joint nucleus? The properties either was of mother or of father. And after the death, the property is devolved. Then under some such circumstances, why the court is talking about joint nucleus?
What I gather from this was not purchased. The court is saying that the property was not purchased out of the joint family property. Rather, it was from the.
Even if it was not purchased from the joint family property, and if the property is purchased from the income of the father, then under such circumstances, after his death, it will devolve equally among the class 1 here.
Yes.
So they are otherwise also entitled to
Yes.
partition.
That is there. That we are seeing.
What is your question of it?
Yes, sir. Page 16, para F.
Page 16. Yes.
The father of the appellate was having a government job and he has been working with the government department for the long period, and the statement of assets which has been given by him in the identity.
No, I'm asking you what is the substantial question of law.
The question is about duty.
You are made so many. बताइए कौन सा एक बताइए. इतना ही है ना?
जी.
इसके अलावा तो नहीं है.
बस यूनिटी ऑफ टाइटल को लिखिए.
बताइए कहाँ है?
पैराग्राफ ई है और and G, sorry, G. The property described in Schedule A of the plaintiff was acquired by Madan Prasad Chaurasia from his own fund. Neither the plaintiff nor dependent on one contributed anything or were in position to contribute anything in acquisition of those properties. So this property actually belonged to Madan Prasad Chaurasia, and on his death, the same jointly devolved upon the plaintiff and the defendants. However, the defendant one in order to set up the causes for that particular first part of it.
Heard the learned counsel for the applicant. The learned counsel for the applicant has submitted that the plaintiff had filed a suit for partition with respect to the properties. How many properties were there?
Schedule A property, let's make page 58.
Schedule A, how many? Item
Four.
number?
Four property.
4 properties. They are only concerned with 1, 2, 3.
Yes, 1, 2, 3.
And what about item number 4?
4 that is ancestral property वो
उसका तो डिवीजन में कोई
उसका
डिस्ट्रीब्यूट
उसमें कोई dispute नहीं कर रहा.
He submits that in the partition suit there were 4 properties in Schedule A. The appellant is concerned only with properties in item number 1, 2 and 3 to Schedule A. The learned counsel submits that the suit was decreed with respect to all the properties. The defendant number 1, his mother, only his mother was the appellant,
Mother हाँ appellant में दो
और किसके साथ वो appellant थी?
Mother and Jitesh Kumar Chaurasia,
Who is
brother of the appellant.
Mother and brother of the appellant were filed appeal before the first appellate court. While he submits that while reversing the finding in connection with item number 1, 2 and 3, the learned first appellate court held that the plaintiff failed to discharge the initial burden that the properties were purchased from the joint previous of the family. The learned counsel submits that after the death of father, his mother and brothers were class 1 here. Class 1 है ना सब?
सब class 1.
Were class 1 here. This is a Hindu succession language. Class 1 है ना?
Class 1
Were class 1 here, and therefore the property would equally devolve upon them, and therefore the partition was rightly made by the learned tribunal. But this aspect of the matter has been ignored by the learned first appellate court. He submits that a substantial question of law being framed on this point. He has referred to substantial question number
G. First part. Page 16.
only first part statement.
First part.
He has referred to substantial question of proposed substantial question of law number G, first part. First part से हो जाए.
हाँ first part.
After hearing the counsel for the appellant, this appeal is admitted to be heard on following substantial question of law. Whether the learned first appellate court, by reversing the judgment in connection with item number 1, 2 and 3 of Schedule A property, failed to consider that the properties were failed to consider the fact that on the face of Exhibit 1, which was a declaration by the father of the plaintiff and the husband of the defendant number 1, the properties were purchased in the name of his wife from the source of income shown from salary, savings and PF. and consequently there was no need to relate the source of income from the joint nucleus of the family. After death of defendant number 1. Issue notice to the respondents in the speed post for which details be filed in 1 week. Call for records from the concerned court. Office to pass speed post delivery with a special messenger post of demand. Post on 8th of December.
Supplementary is forwarded with action 2. First appeal filing number 7351 of 2025.
For ignoring the defect notes, we have filed an IA, but the defect is with regard to the payment of court fees. The suit has been filed only for declaration that a sale deed is null and void and not binding. In the court below also, we have paid a fixed court fees, but here note the stamp reporter has pointed out defect to pay ad valorem court fees. The Lordship is aware notes Section 7 of the Court Fees Act and Schedule 2 13, which deals that if it is only for a declaration without any consequential relief, then a fixed court fees is paid. The Lordship may first see note the memo of appeal itself. But a fixed court fees was paid in the court below. ये बड़ा हाँ. But may see the schedule and I will cite a direct judgment notice which covers this. The first paragraph itself shows that it is a suit for only declaration.
Any point on court fees made, any point for or any issue on court fees paid by the court?
No
issue was
no issue. But the stamp reporter here has pointed out, note, this is a judgment note which, in my humble submission notes. The Lordship may first see the Lord's Act first, but I've just passed on my copy. The Lordship may see Lord's first schedule is with respect to, but second flag.
Yes.
First schedule is for ad valorem court fees. The Lordship may see second schedule which deals with fixed court fees. The Lordship may kindly flip the page note. It is point number 13.
Yes.
I have marked.
Plaint or memorandum of appeal in each
Yes.
of the following suits. To obtain a declaratory decree where no
consequential relief is paid, it is only fixed court fees. And now your Lordship may kindly see the judgment notes. The judgment is also there.
FA number, filing number FA 7351 of 2025. The learned counsel for the appellant has submitted that IE number 12249 of 25 has been filed for ignoring the defect with regard to payment of ad valorem court fees. He has referred to Court Fees Bihar Amendment bracket close Act 2007. ऐसे लिखा है था Court Fees bracket Bihar Amendment bracket close Act 2007. Schedule 1. No,
Schedule 2.
Schedule 2. Clause entry 13. To submit that in a suit seeking declaration without consequential relief, a fixed court fees of ₹1,000 is payable. पढ़ा नहीं इसके बाद?
Name.
The learned counsel submits that the office has pointed out the defect that ad valorem court fees would be payable. He has also referred to judgment passed by Honorable Patna High Court reported in 2008, Supreme Court Patna 237. Para number?
Yes, ma'am. But paragraph notes, here notes the objection was taken by the stamp reporter. Paragraph 5 your lordship will see. Where notes, after the objection, the court says the law is well settled in this regard. As against the deed of transfer, two sorts of relief can be sought. The first is declaration that the deed may be cancelled or avoided, whereas the other is a declaration that the deed is void ab initio, having no legal consequences and not binding on the plaintiff. In the instant case, the claim of the plaintiff is that he has got title and possession over the suit properties and that the sale deed in question was void ab initio and not binding upon him, but he has not sought any relief that the sale deed may be cancelled or avoided. In this situation, what the court has said, relying upon Supreme Court judgment, on same
Paragraph
paragraph.
5 and 6.
Yes.
The relief as paid for in the suit is for a decree of declaration of sale deed number 1377 dated 17/11/2017 executed by defendant number 2 to 10 in favor of defendant number 1 be declared null, void ab initio, void, not acted upon, and inoperative and not binding upon the plaintiff. Considering the nature of relief and the aforesaid provision of law and the judgment, the office objection with regard to payment of ad valorem court fees is hereby taken. Office to proceed.